Picture this: a 7-year-old child is taken across a border. One parent is in South Africa, the other overseas. The child is caught in the middle. The parents go to court, but not the same court, not the same country. Months pass. The child's life is suspended. And the question no one can seem to answer is, who decides? This is not fiction. This is happening right now in our courts, in our country. And our current legal system isn't built to handle it. I'm Simon Dippenaar, a family lawyer based in Cape Town. In this video, I want to share a vision rooted in law, empathy, and global best practice of why South Africa urgently needs a specialist court for international family law. As cross-border families become more common, the legal disputes they face about care, contact, relocation, or abduction require speed, consistency, and deep expertise. We don't have a court right now to deliver that, but we should. Let's start with the gaps. South Africa is a globalized society. We have South Africans married to foreigners, children with dual citizenship, and parents who move for work, safety, or opportunity. But our court system, especially when it comes to family law, has not evolved to meet these global realities. When a parent wants to relocate a child abroad, or when a child is wrongfully retained in another country, or when a foreign parenting plan needs to be enforced locally, there is no designated court to handle these disputes. Right now, these matters land wherever they happen to land. In the High Court, if someone applies, or in a magistrate's court, if it involves maintenance of contact. Judges do their best, but most are generalists. Many have never dealt with the Hague Convention. Others are unfamiliar with how to handle mirror orders or foreign expert affidavits. And as a result, families face legal fragmentation, conflicting rulings, and long delays. In one case, RH versus NM, the court had to weigh between relocation to Australia and France, balancing school reports, psychologist recommendations, and financial affidavits. The judgment was careful, thoughtful, but it took months. In Hague Convention matters where children must be returned within 6 weeks, our courts have often missed that mark badly. Judges get drawn into full custody hearings when the Hague only requires a decision on wrongful removal and habitual residence. This confusion and delay hurts the very children the law is meant to protect. So what would a specialist international family law court do? It would do what other successful jurisdictions already do. In the UK, the family division of the High Court handles cross-border disputes. In Australia, Division 1 of their family court system is staffed entirely by family law specialists. In the Netherlands, all Hague Convention cases are heard in The Hague by expert judges. These systems have one thing in common. They treat international family matters as a legal specialty, not a procedural accident. And it works. A South African specialist court could fast-track Hague Convention cases, create uniform guidelines for relocation matters, provide clarity on enforcing foreign judgments, maintain a panel of experts, psychologists, translators, and cross-border professionals, build internal judicial expertise in private international law. Most importantly, it could give children and families predictability and protection. When you walk into that courtroom, you'd know the judge has heard dozens of cases like yours, not just one or two over a career. That matters. Let's bring this back to people. Every delay in a child relocation case affects that child's development. Every day a child is unlawfully retained in another country, they become more rooted there, making return harder. And every inconsistent ruling teaches parents one dangerous lesson, that outcomes depend more on who you get as a judge than what the law says. We can and must do better. Justice in these cases must be child-centered, but also timely, coherent, and global in perspective. A specialist court can ensure that. This isn't just a dream, it's viable. South Africa already has specialist courts for competition law, tax, labor. Why not for children at the intersection of two countries? The structure could be a division of the High Court, staffed by judges with training in family and international law reform commission, the Office of the Chief Justice, or even the Department of Justice could begin with a pilot. Johannesburg, Cape Town, Durban, 3 centers, 1 unified standard. Over time, this court would develop consistent jurisprudence, reduce appeals, and streamline cross-border cooperation. And the long-term savings of time, trauma, and unnecessary litigation could be profound. I believe we are ready. We have the legal minds, we have the constitutional commitment to children's best interests. All that's missing is the structure. To every judge, policymaker, family advocate, and practitioner, we don't need more law. We need better tools to apply it. We need a court that speaks the language of relocation, abduction, habitual residence, enforcement, and mirror orders. We need a place where families in crisis across 2 continents can find clarity. We need a specialist international family law court, and we need it now. I'm Simon Dippenaar. Thank you for listening. Let's build this vision together.